Okay, so we're starting on our lunch keynote, and I'd like to introduce Mr. Tom Isaac, who was when we invited him, he said yes right away, which was amazing, knowing that he's very busy. So I'm going to read his biography, and then I'll let him take over. So Tom Isaac is a nationally recognized authority in the area of Aboriginal law and leads Castles, Brock, and Blackwell. What does LL? Okay. National Aboriginal law practice. Mr. Isaac regularly negotiates on behalf of industry and governments in respect of impact, benefit, and access agreements with Aboriginal groups, and he advises on Aboriginal consultation and accommodation processes and agreements. Mr. Isaac has represented industry and government clients before the Supreme Court of Canada, Federal Court of Canada, Ontario Court of Appeal, Ontario Divisional Court, BC Court Appeal, BC Supreme Court, etc. He has published extensively in the area of Aboriginal law, including 12 books on Aboriginal legal matters, including the 5th edition of his text, Aboriginal Law. His published works on Aboriginal law have been cited with approval by Canadian courts, including the Supreme Court of Canada and the Federal Court of Appeal. He is a former chief treaty negotiator for the Government of British Columbia and former assistant deputy minister responsible for establishing Nunavut for the government of the Northwest Territories. He also served in a senior capacity with the government of Saskatchewan dealing with Aboriginal issues. Mr. Isaac has served as the ministerial special representative to the Minister of Indigenous and Northern Affairs regarding a Section 35 Métis Rights and Reconciliation Framework and a reconciliation approach for the Supreme Court of Canada's decision in Manitoba Métis Federation versus Canada. Mr. Isaac's report, A Matter of National and Constitutional Import, Section 35 Métis Rights and the Manitoba Métis Federation decision, was released by Canada in July 2016. And this is the report, and we have a few copies here. Mr. Isaac sent some to us, but it's also available online, and I think it's a good report to read. Actually, my students in my Métis politics had to read that report. I'm sure they loved it. Mr. Isaac is also presently serving as the Minister's special representative to conduct exploratory discussions on the Goffredson class action lawsuit against the Government of Canada relating to residential day schools. Mr. Isaac is a member of the Law Societies of British Columbia, Alberta, Northwest Territories, Nunavut, and the Yukon. So please welcome Mr. Isaac.
Thank you. Thank you very much. Pleasure to be here. I want to congratulate the organizers of this obviously very important gathering. I've had the pleasure of attending many gatherings with Métis and with others on Métis rights over, more than over the past year, but I think to have a crowd of this size, and I understand perhaps hundreds more online, I think speaks to an obvious point that I think most of you would agree with, that we are in the midst of something now. I think a year ago when I was speaking, and by the way, it's very nice to see so many friendly faces and many of the Métis leaders and representatives I got to meet over the past couple of years here today. But it's obvious that we are in the midst of something, something very special, and I'll say not only for Métis but for the country. And so again, in that context, thank you for the invitation to speak. We have seen a steady development of Métis-related case law. We've seen, and that's really primarily dealing with hunting rights and dealing with the land entitlements under Section 31 of the Manitoba Act from Ontario westward. Of course, we have the Manitoba Métis Federation decision in 2013, a significant decision not only for Métis in Manitoba and for Métis generally, but also in respect of further developing Section 35 in terms of the court's extensive discussion of the principle of the honor of the Crown. It's the leading decision on that very important concept. As you know, the Government of Canada appointed a Minister Special Representative to look at the issue of Métis rights from a Government of Canada perspective. And remember, this was before Powley in the summer of 2015, and I was delighted to take on that role, knowing the historic significance, again, prior to the Daniels decision, of Canada wanting some advice, some independent advice on how they should approach the Métis issue. Of course, the Daniels decision, which you've already heard about, and I know you'll be hearing more about over the very impressive number of speakers that you've got lined up over the next few days. My report on Métis rights issued last summer, which I think it's fair to say has been, at least from my perspective, it seems to have been well received. I still don't know how governments are receiving it. Maybe some of you can shed some light on how governments are receiving it. And most notably in recent months, and Will spoke to this, the significant developments with the Manitoba Métis Federation. And what we are seeing in the recent signing of a framework agreement and the Government of Canada going down what on its face appears to be a very serious road of reconciliation with the Métis in Manitoba. And of course, the meeting that's coming up next week with Métis representatives and the Prime Minister. So all of this happening really in 18 months. I guess if you include the Manitoba Métis Federation decision, a little bit longer. But really within a few years, momentous movement. And the fact that I'm speaking here today in Alberta isn't lost on me, that a few short years ago, I remember speaking at a conference in Calgary, talking about challenges around getting the Government of Alberta to acknowledge that the duty to consult applies to Métis people. Which I understand may still be a bit of a, that's probably another discussion, but just the notion that the duty to consult could apply to Métis, even though the law 10 years ago, 12 years ago, was abundantly clear from the Haida case that of course it applied to Métis, we still had governments, including at one point in this province, provincial governments trying to argue that the duty doesn't apply to Métis. And I'm not at all suggesting that we're done or you're done on that battle of having governments understand what existing Canadian law says about the application of the duty to consult. But to think that we're having a conference like this, and I was able to rhyme off really very quickly some very significant historical events that have happened in essentially a few months, relatively speaking, I think speaks volumes. So again, I congratulate the conference and or the organizers for putting this conference together. And it really is, and I know for many of you, a very exciting time, a very daunting time though, and of course with that comes its challenges. And so I'd like to give a few comments today. I was asked to speak a bit about my report, so I will give a few comments on that. I'll apologize now to at least a few of you who have heard my comments on my report. At least there's a couple of you that have probably heard my comments 7 or 8 times by now, so I'll try to add a few things different. And then a few comments on the very important Daniels decision from my perspective. And then I'd like to end with a couple of very brief comments on reconciliation and the path forward for our country. So in terms of my report, I really do try to do this. I'm a lawyer. That's how I earn my living. And I have lots of files going. And it's very easy, at least in my business, to, I go home and play with my kids at the end of the day, and I really try not to think about Aboriginal law, just so you all know. I eat and live Aboriginal law pretty much 7 days a week and have for about 25 to 30 years. And so it's usually typically easy for me to build a wall and just jump over the wall when it's time for me to make pizza on Friday night or whatever the task is at hand. I have to tell you that this particular assignment, it wasn't so easy for me to do that. It was a profoundly important assignment for me that I actually didn't expect to be as moving as it was at a very personal level. And so I do want to just thank again the Métis women, the Métis men, Métis children actually that I got to meet, and continue to meet actually on a few other assignments now for educating me on the wonderful history and culture of Métis. So my report is called A Matter of National Constitutional Import. I assume for most of you, you know where that title comes from. That is a direct quote from the Supreme Court of Canada and the Manitoba Métis Federation as the court is describing the need for reconciliation with Métis with the Crown, and describes that need as a matter of national and constitutional import. And for me, I thought there could not be a better title for what I had to say on what I observed. And obviously, Canada, again, pre-Daniels, looking at the issue of Métis was in and of itself historic, as all of you, I'm sure, know, given what the court called in Daniels the jurisdictional tug-of-war that had been going on, and I'll suggest continues to go on, and I'll talk a bit about that, notwithstanding the very clear decision in Daniels. So I was appointed in July of 2015. Of course, there was a federal election in the fall of 2015. I was appointed originally by the Harper government. My appointment was reaffirmed by the Liberal government in December 2015, and my report to Minister Bennett was released in July of 2016. I was and remain independent and nonpartisan. I extended an invitation to all those peoples in Canada who held themselves out as being Métis. I did not make any determination of whether or not a group that I spoke with met the Section 35 criteria under Powley, even though, as you know, for those of you who read the report, know I focus heavily on Section 35, given that was really what the mandate was. And that was important for me because I thought it was very important to hear everyone's views on this. The mandate was twofold: give the Government of Canada recommendations on establishing a Section 35 rights framework. I will tell you that that part of the advice was very simple. I didn't find it particularly challenging to come up with views about what a process could look like. It should be fair, transparent, and inclusive. and consistent with the honor of the Crown. Second part of the mandate dealt with the declaration issued by the Supreme Court of Canada in the Manitoba Métis Federation decision, where the court stated that the Crown had breached the honor of the Crown in implementing Section 31 of the Manitoba Act, and to give advice to Canada on what it should do with that, which I did. But key to both of those parts of the mandate, which were really essentially process-oriented, the mandate I received personally from the minister, I would say both ministers, both reiterated to me the importance that they must further the objective of reconciliation. And therein, for me, was the hook. It wasn't on recommending a process of who to talk to. I mean, that, again, all of the Métis governments and institutions I met with were very articulate and clear in terms of what a process could look like. And let's be honest, it was fairly straightforward what needed to happen, or what needs to happen, excuse me. But it was this issue of the objective of reconciliation, so that whatever process we were putting in place, it had to further reconciliation. And so when I was meeting with the various federal departments and representatives and provincial and territorial representatives, Métis governments, Métis institutions, Métis leaders, and Métis citizenry, it was essential that I viewed that through the lens of, well, will that further reconciliation in terms of the process? And it was as a result of that that really I ended up making all the other comments that I made in the report, because they don't deal with process directly, but in my view, they deal critically with the issue of reconciliation. And so the first theme that for me comes out of the report, and I'm not going to run through all the recommendations given the time that we have today, and I know that I was told that we want to give lots of time for questions or comments, but was this theme of recognition. I came very quickly to the conclusion that in order to have a process about Section 35, you have to understand Section 35. There's no use having government officials come in and have a meeting with you if they don't understand what they're talking about or what you're talking about. And I have to tell you, it was a surprise to me that the gap in knowledge between what Section 35 means, and I mean from an unarguable perspective, I don't mean what your lawyers may argue in terms of trying to push the law, I mean not debatable. Of course, the duty to consult applies to Métis. I'll run through a few examples here in a minute. And it was, I'll be honest, it was disturbing to me, and I'm not picking on the federal government here, I observed this in the provincial governments as well, of a huge knowledge gap between what is and what they thought the law to be. And so how can you even engage in an initial discussion when one of the parties at the table doesn't even know what the law is? What the law is. I'll leave it to you and your lawyers to figure out what the law ought to be. I know what the law is, and I did my best at trying to articulate what I thought were unassailable legal principles in Canadian law. And so my very first recommendation, it was very deliberate, was the need for education. And education about Section 35, education about Métis culture, the significance of Métis to the development of our country, and the need for us to be proud of that history. And core education around existing case law in Section 35 and Métis rights, of which we now have a significant amount of, we're not done, but we have a significant amount of law. This isn't a vast gray area that we don't know. There are questions that still need to be answered, but we have the basic tools. And let me just very briefly, I have to mention these because I like cutting to the chase, of any of you who know me well, you'll know. I talk about it in my report. I heard a few myths. Métis rights are derivative from First Nation rights. False. But I heard this from senior people. I heard this from industry representatives. I heard this from, and I'm not trying to paint everybody with the same brush. There were also many lawyers that I spoke with acting for governments who knew what the law was. But I heard this enough that I wanted to put it in my report. That's false. Métis rights are not derivative from First Nation rights. Treaty rights trump Métis rights. No, you all know this, but I heard this. I heard this from gatekeeper, what sort of in some of these various government systems, and I'm not going to get into the naming names today. I don't think that's helpful necessarily. They all know who they are. Trust me, I've met with everybody privately after my report came out. I did. And of course, treaty rights don't trump Métis rights. Treaty rights, First Nation treaty rights, or Métis treaty rights, are protected equally by Section 35. You don't need to consult with Métis on certain issues. I won't get into the whole thing I heard about. No, wrong. The test that is set out in the Haida case, reiterated specifically in the Engie decision in the Northwest Territories, applying specifically to Métis, but it's the Haida test. The same test that applied to the Haida Nation applies to Métis. There's not a shred of case law to stand, not a shred, not a word, of which I am aware that stands for the contrary. And yet, I heard time and time again, I give the example in the report of the government of Manitoba, who consults with northern communities. And again, I want to be clear, I'm not here to criticize the northern communities or the governance structure, but the law is abundantly clear that if you have public forms of government or mixed, so you may have, for example, First Nations and Métis as part of these northern governments, but they do not represent the rights holders. They cannot at law unless the rights holders expressly empowered those governments. This isn't open for argument. This is expressly from the Supreme Court of Canada. Sorry, I'm going off, and I could talk for an hour on that one point. And yet, and I'm sure Will and others from Manitoba will confirm this. We've got lots of examples, and I use them as an example, but to me it's an appalling example of where Canadian law is very clear that you must consult with the rights holders, the asserted rights holders. And yet you've got the government of Manitoba saying, well, we consult with the northern communities. We don't always have to consult with the local, whether it's a Métis or even the First Nations in some instances. And so you have all these myths out there. And again, I could fill up a page of other myths I heard, and they're false. And they're completely false. And so why there's this lack of knowledge, I didn't come to a firm view on. I do think part of it is that there's just a general lack of education. I think we've seen a lot change in the past 18 months. I think thanks to you and conference organizers, some of the Métis leaders that I know in this room, that is changing, and it's, I think, changing rapidly. From my observation, I travel across Canada monthly, and I can tell you, from my, as a non-Aboriginal person, but immersed in these issues, I would say things are changing fairly rapidly, relatively speaking. I think that there is a tendency for governments, so not just the federal government, to view things myopically. I've been on numerous files recently where I've seen the same symptom over and over and over again, whether it's dealing with Métis. I won't name the other issues right now because I'm currently engaged on a few things, but I'm seeing a theme, folks, and it's this. We've had our way of doing it, and so even in examples that are offensive to all of us as Canadians, you will have smart, intelligent people argue things that don't make sense. And I'll give you an example a little bit later. But I think fundamentally it's really a denial of understanding Section 35. I've mentioned before, so my report came out in July. In August, Tom Flanagan wrote a piece on my report, and it was titled, Isaac Report Goes in the Wrong Direction. Surprise, surprise for anybody who follows that, by the way. I thought to myself, I'm doing something right. That's not a bad sign. But when you read, but in all seriousness, when you read, first of all, he actually says I counsel the government to spend more money on Métis. For those of you I know who are bitterly disappointed, I don't do that in my report. I do tell Canada to spend money equitably. And I'll come back to that in a moment. It's not my job to tell governments how to spend public monies. But it is my job to show them the Constitution and say you've got to treat Métis equitably under 35 in the honour of the Crown with First Nations and Inuit. But when you read Tom Flanagan's piece, and again, it was August, do I have the date? No, I don't. So it's August 16th, Globe and Mail. Oh, no, it must have been National Post. What am I thinking? It must have been the National Post, August 2016. But what his real issue is in that column, he doesn't like 35. That's the real point. And look, I don't agree with it. I think 35's been good for our country, but I respect the fact that people can have a different opinion. But we need to have an honest dialogue about that. And the fact is, it's in our Constitution, and it's the highest law of the land. So, but key to recognition is understanding the law. And those of you who read the report will know I spent a lot of time on the law. It was deliberate. I didn't spend a lot of time on Métis culture and history. I'm not an expert on Métis culture and history. And the one thing I learned after my engagement is I will likely never be, because it's rich and it's diverse and you need to really immerse yourself in it. But I wanted to make sure that I respected the fact that I wasn't an expert. So I like to talk about things that I know about, not things that I don't have a full appreciation of. But the law is critical to understanding the recognition required under 35, which of course that's what my mandate was focused on. Section 35 equally protects Métis rights equally with the rights of the Inuit and First Nations. Métis are one of 3 enumerated Aboriginal peoples, and there is no hierarchy of rights. One of the themes I kept hearing, certainly not from Métis, but from governmental officials at times, was this underlying theme that, well, there was a hierarchy of rights. There's nothing in the case law to suggest that. And so I thought it very important not only to suggest folks get educated on Section 35 and Métis rights and Métis case law, of which we have now an abundance, but also understand what that means vis-a-vis practicing the act of governing. And so in a very, I tried to keep the report very short. I tried to set out what some of those things look like. And of course, I started with noting that Métis are distinct Aboriginal peoples. There's no, there's obviously a history there, but there's a distinctiveness that the Supreme Court recognized early on. Governments haven't recognized it early on. Some governments are now coming around understanding what you already know, that Métis are distinct peoples. But the law has also been clear, in my view. I remind people, of course, with Pauli, look, the Pauli test for proving Métis rights is the same test to prove First Nation rights, with one exception, the requirement for pre-contact evidence. It's the same test. The Vanderpeet test for First Nations, the Pauli test for Métis. We need to find ways, as I talk about in the report, of respecting different ways to govern. I met with a number of Métis leaders who talked about they would like governance regimes that aren't necessarily based on land. Some want land, some have land. We heard from the settlements, of course. Very unique right now, currently in Canada. But we need to open up how we view governance, and this was my advice to government, that don't be so focused on, again, a myopic, Indian Act type system, or must be land-based. It doesn't have to be land-based. We can do whatever we want in this country if we want to do it. Now, we are still, of course, in the infancy of understanding, notwithstanding the abundance of case law, we're still in the infancy of understanding Métis rights fully under Section 35 and understanding the nature of Métis claims under Section 35. We don't have processes in place and we need them. And certainly my advice to Canada, and of course my advice, I was reporting directly to Canada, but again, for those of you who read the report, I didn't hesitate to give advice to the provinces. And I stand by that even after Daniels, and I'll tell you why in a moment. Because it's all part of one crown. But we need processes to deal with claims like, and we've got the framework agreement for the Manitoba Métis Federation, the Treaty 3 adhesion claim, the Northwest Saskatchewan claim, the pastures policy. And again, some of you are expert on these things. The Dominion Lands Act script commissions, and the list goes on. I heard a litany of examples, and those are only a few, a litany of examples that warrant further dialogue and attention from government. The myopic views, let me just very briefly mention, I have to mention this one example because it touches individuals. Many of you will know that currently under the Indian Act, if your name is on a registry, you can't get your name off the Act. I didn't know that until I was appointed, believe it. I mean, I've done a lot of work in the Indian Act. I didn't know that until I was appointed and looked at the Métis issue. And I thought, no, this can't be correct. Sure enough, of course, it is correct. So I met with the experts, and I don't mean that in any pejorative way, people who know the registry inside and out, the Indian registry. I said, explain this to me. Is this true? Oh, yeah, absolutely. So I said, well, does anyone have a problem with that? That a Canadian, this is before we even get to 35 and Métis, a Canadian is being told by the state who they are. No, we've got to worry about legal liability and all sorts of. So nobody finds this offensive to the human spirit. And again, this is before I even get to the Métis, okay? That the state could tell you who you are even though you're not who they say you are. And you could slowly see light bulbs going on around. You can remember the walls and the myopic vision. And I saw it firsthand. And so, again, for those of you who read the report, you'll know that it's one of the few times I use the word immediately. Canada should immediately introduce legislation to amend and allow Métis to be Métis. I met with I met with all of the registries. I was impressed with all of them. And I remind folks that those registries, sometimes it gets, well, the Indian registry. Hold on. And I say this with due respect, by the way. This isn't a criticism of First Nations or the Indian Act registries, but those are not Section 35 registries, folks. Those are registries for the purpose of a piece of federal legislation that's draconian and antiquated. The Métis registries that are being developed are 35 registries. Could anything be more important to public policy development in the country than giving governments, again, forget about the Métis for a minute, giving governments certainty of who holds 35 rights? And again, what is so apparent and so obvious that governments should be crashing down the door, in my view, to be providing stable, long-term governments, not just Canada. This is in the provincial interests as well. And it's lost on me as to why that isn't happening. And I'm sure some of you have much deeper insights on these things than I do. So let me very quickly, I just want to touch on a couple things. On programs and services, and this does link to Daniels. I don't talk about new monies for Métis. I do talk about whatever money Canada determines that it wants to spend on Aboriginal peoples. It should do so equitably. And a proportion of a minute proportion of a further minute proportion of the INAC budget being distinctly designated for Métis is not sufficient. I heard lots of examples of sort of folks very proudly telling me about non-distinction-based funding. Well, that's fine for First Nations when you've got a whole bunch of distinction-based funding. But when you're the Métis, and you have almost zero, relatively speaking, distinct Métis-based funding, the notion of being lumped into some non-distinction-based programming, and I use the urban Aboriginal strategy as an example, you don't get to check the Métis box for that. And I want to be very clear, and I make it clear in my report, I'm not criticizing the urban Aboriginal strategy. I'll leave that, folks have different views. That wasn't my comment. My comment was, though, you don't get to check the Métis box with that. You can get to check the Aboriginal box. You can get to check an urban strategy box for Aboriginal people's box, maybe. Some of you may debate that even. But there is a need to treat Métis distinctly. It is the Department of Indigenous Affairs, not First Nation affairs or Inuit affairs. And again, I know this is trite for most of you, if not all of you. But what is trite and what's obvious, I'll suggest to you, isn't so. And I felt compelled that I needed to draw this out. And treating Métis as Métis. And I argue in the report that the honor of the Crown requires this. And that if we're serious about reconciliation, reconciliation requires this. Role of provinces, again, I won't belabor the point on this, but the provinces have to be involved. And this leads me into Daniels. I heard, first of all, an extremely important decision, but I'm going to suggest not for the reason of what it said about 9124. On its face. I was of the view, I think like many lawyers, that obviously Métis are included within the use of the term Indians within. Now, I don't want to downplay the significant, very significant, the court confirmed that. Once you get over that, the implications out of Daniels, though, in my view, are profound. Because look at the use of the language that the court uses in that decision. It starts using this term Indigenous now. And Indigenous meaning Section 35 Aboriginal peoples. The court then makes this reference to Métis who may not hold Section 35 rights. There's a debate. And then refers to non-status Indians as something somehow another category. And my point is, though, that there's some further clarification required from the court, but we now have an identifiable group. A very clear identifiable group for the purposes of legislation. Again, forget about 35 now for a minute. So then you ask the question, well, why is it that some Indians under 9124 have distinct programs and services and some don't? Again, that's for another whole discussion. I mean, that's an hour, 2 hour, a 5-day conference. I'll suggest to you the answer isn't very simple. And it raises more questions than answers. And again, that's not a critique at all of Daniels, quite the contrary. It's raised a profound question that I think aligns very nicely with the point that I make in the report from a 35 perspective of treating Métis qua Métis, as Métis. And I see a dovetailing between 9124 in that respect and Section 35. One other comment on Daniels. I was at a number of conferences. Actually, Will, you were at one of these conferences. I forget actually which city we were in. But where one of the provinces basically said, well, we won. Right? You know these provinces. One of the Western Prairie provinces, surprise, surprise. Actually, 2 of them suggested we won. No, they did not win. What an impoverished view of our country. What an impoverished view of Section 35. What a complete misunderstanding of what the court was doing in Daniels. It didn't let the provinces off the hook. Quite the contrary. Provincial laws continue to apply. The court came right out and said it. In fact, federal parliament doesn't even need to legislate in respect of Métis. But that doesn't take away the importance of taking out the jurisdictional tug of war, the fact that provincial laws continue to apply, and the fact that Section 35 is layered on top of all of this. And the notion that provinces can walk away from this, I think is just profoundly misguided, and I think is a mistake for many of the provinces. They're not taking advantage of an opportunity. But Daniels, in my view, raises fundamental issues around identity, responsibility, reconciliation, and what it means to be Indigenous in Canada. I will say that I think Daniels raises many more questions, not for the Métis, but for First Nations, profound questions for First Nations. and profound questions for governments about what it means to legislate in an area and what that actually means. It's just policy, folks, as opposed to 35, which is not policy. Your laws are subject governments to Section 35. So I think I've already talked about Indigenous peoples and I'm just about to conclude, but I do think that there's some very interesting discussions that flow out of Daniels about, is disadvantage relative? Is it okay that one group of Indians under 9124 is severely below the national standard on healthcare or education, and another group like Métis, depending on what part of the country you're in, is just a little bit below? And just because somebody's a little bit below, you can go, well, no programs for you. We've got a group that's much worse off. And essentially, I think that can be a description to date of what we are seeing. And even the folks that are far worse off will tell you things aren't great. But this whole idea of relative disadvantage and what that means, surely that's not what we're about in terms of honor of the Crown and reconciliation. So for me, Daniels raises profound public policy questions about how money is being spent and how money ought to be spent. I don't give guidance in my report. I wasn't asked to give guidance, and I thought it would be inappropriate for me to give guidance about what that would look like. What I did do was try to focus on key legal principles that I thought would help Canada. Things like fairness, equity, honor, reconciliation, our Constitution, that these things should serve as very helpful guideposts for the Government of Canada and, quite frankly, for the provinces and the territories dealing with these issues. I see Daniels as a huge opportunity for governments to recalibrate how they spend public monies and what objectives they are truly trying to achieve. And again, I'll leave that to smarter people to discuss. So let me conclude. I've covered a lot of ground very quickly, so let me apologize now, but I did want to make sure we left some time for some comments and questions. Look, we've got 60-plus decisions from the Supreme Court of Canada in 26 years on one sentence in our Constitution, Section 35. A profound amount of law in a very short period of time. There's not another sentence in our Constitution that has received that kind of attention. But we're not done. It's clear that we're not through the first chapter of the book on Aboriginal law and understanding fully. On Métis rights, we have significant decisions guiding us. Powley, Cunningham, Blais, Manitoba Métis Federation, the single leading guidepost on the honor of the Crown, which, by the way, I very seldom hear First Nation lawyers mentioning. It's very interesting. You don't hear a lot about it outside the May. It's the decision on the honor of the Crown. And, of course, Daniels. We are in a very dynamic environment right now. You all know this. I think it's a very exciting time for our country. I think that reconciliation is an opportunity for our country. I think it's legally mandated from the court. And as I write in my report, and I heard this from many of the Métis leaders, so I actually borrowed it from you, but reconciliation has to be more than platitudes. I'm sure many of you have had enough of the platitudes. It must be based on concrete actions. And this is a lawyer talking, but this is clear from the court, that if we are going to achieve what we need to achieve as a country, it has to be based on concrete actions. And I think, if anything, the discussion that's being had right now about Métis rights will hopefully help reframe the dialogue for the 21st century of how Canada now moves forward in terms of reconciliation and make our country a better place and sort of live up to its promise. So those are some very brief, quick, rambling comments, but I hope those were useful. Thank you.
Thank you very much, Tom. So we'll take some questions now. a few questions before we move to our next panel. Yes.
Good afternoon. Thank you for that wonderful presentation, Mr. Isaac. I just wanted to tell you that lately our community has been sort of working with the Crown, and one of the things that we noted when they were consulting with us is that they had a guideline for consultation, and in one of the letters they put to us is that the Métis were at the modern end of consultation, and from that they framed how their conversation would take place with us. Well, we went and we did several sessions with them, and our community members, they had a lot to say, and then when they wrote back to us on what was said in the meeting, it was really very much condensed. They had information that was incorrect, and there was lots of corrections that had to be made. So when we finally put together the last submission to them when they responded to us, we said that they may not have properly consulted with us because their guidelines were written back in 2011, and actually I used a quote out of your report that there is no hierarchy of rights, because if we're at the modern end, who's at the other ends? And we Métis, we know the answer to that question. So I want to thank you for the great work that you've done. I want to tell you, I'm not a lawyer, but we applied what you put into your report into what's actually taking place in northern Alberta, where I live with my community members. Thank you.
Oh, thank you.
Go ahead.
Kim Bowden, Vice Chief of the Congress. In your discussion, you talked about the Indian Act, and you referred to the issue of if people are on that list, that they could not get off that list due to the Indian Act. And I was wondering if people had, we'll say bands that were disenfranchised or enfranchised, if they were on that list prior, and all of a sudden the government comes along and enfranchises the whole band, and there are 2-3 of them. There's probably at least 3 in this province alone. 2 right out of Edmonton. Would they still be on that list? That's one question I had with respect to the membership or the members who were on that list and the descendants. And the other thing, in your report, you talked about consultation. And I noticed you put the Congress on there, and you put OCAP, Ontario Coalition of Aboriginal Peoples. And the President, Brad McGraw, had asked me, he was saying he asked me to ask you with respect to consultation, because he said he was never consulted with. That was one. And in terms of the Congress, I was a board member as well for 7 years. And I can't remember if we were ever consulted with either. Granted, with the report, there's a lot of information in there. Some of it we certainly agree with. And it's too bad, because we would have had some really good input to provide as well. So that's the question I'm going to ask you. I know it's being, so actually some of the people on the CAP board are most likely watching this right now. Yep. And I mentioned I would bring this up. And I'm certainly interested in that question with respect to the Indian Act itself. Thank you.
Okay, thank you. So in respect of the Indian Act question, I don't know. Sounds like a really interesting question, but I really don't know whether their names would still be on the list or not. In terms of consultation with respect to the report, every entity that was listed at the back of the report was in fact consulted with. So with respect to CAP, numerous requests were made to CAP. Absolutely willing, and in fact I met with, I can give you the name afterwards, but in fact I met with one of your representatives, one of your staff people, certainly was willing to have whatever depth of dialogue CAP wanted to have with me. I was very pleased that I was able to have at least a conversation, but I have no idea whether that was communicated fully or not, but I certainly had at least a couple of pieces of correspondence to CAP inviting them to consult with me.
Hello, Mr. Isaac. My name is Ewald Bergen, and I'm from Kelowna. And first of all, thank you to the organizers of this wonderful conference. I have just a very short question for you. In your 2 decades plus engaging with government officials, federally, provincially, and so on, I'd love to get your personal opinion on how they're doing ridding themselves of their colonial mentality.
I'm usually not at a loss for words, so I have to think about that question. You know, I'll say this, and I am not speaking in respect of just the mandate on the Métis rights report, but you know, I think it's clear that governments are really challenged by these issues. I mean, I've been very critical, notwithstanding that I act for many public governments in litigation and otherwise. I think, generally speaking, I've been very critical of the lack of a sustainable public policy approach. I mean, some of you will know that I give a whole speech on the need. The biggest single challenge I see in Aboriginal law are not Aboriginal peoples, and I act for industry, okay? Not Aboriginal peoples, not the courts, but the lack of a sustainable public policy approach right across the country. And, well, that policy's being made off the end of this. And election cycle thinking. And I've said numerous times publicly that these issues do not lend themselves well to election cycle thinking. We're dealing with people's lives, people's identity. We are dealing with the Constitution, and they require thoughtful, and that works both ways. So I do a lot of work. I won't get into the provinces, but I do a work in a province that it's got a lot of First Nations. And if you're part of the Sweetheart group of First Nations, you get the Premier's phone number. If you're not on the Sweetheart list, you don't get the Premier's phone number. There's something wrong with that. There's something fundamentally this is, again, from a First Nations perspective. I just throw that out as an example. So my counsel to all public governments has consistently been, and I have to tell you, I haven't changed the advice in about probably 15 years now, is say what you mean and mean what you say. A very simple proposition, but this idea of just trying to get through the next election cycle, of making promises, yeah, we'll do this, and you know better than me. I mean, the problems that causes. So, you know, this reconciliation business is tough stuff. It can be painful, but what is required is truth. And so, and it's core to reconciliation. It is absolutely the core of reconciliation is truth. And so we have to create an environment where we can have truthful dialogue. And it doesn't mean everybody's going to agree, but the platitudes in that, we have to start moving beyond that. I think we're starting that. And again, I would say that every government's different, and every department within the governments are different, and they're all struggling in their own way. But I do think this sort of election cycle politic is a very challenging proposition, and probably for the politicians as well. You know, it's very challenging. But I think we've got to move beyond that kind of dialogue, in my view. But there's lots of bright lights out there. There's lots of good things happening. I mean, we just ran through some examples, even on the Métis file in short term, that there's some light at the end of this tunnel. But for every positive story you can tell, you know, you again know better than me. You can tell 5 where, you know, we're still not on the, you know, we're not on the center line. And so this isn't going to happen overnight. And that's what always has bothered me, is when I hear these promises, and, you know, there's a couple of provincial governments in particular that, you know, the next piece of legislation or the next big policy announcement will solve all the problems. Well, no, it won't. You know, this thing's going to take some time. And I think that's okay, as long as we are honest about it, as opposed to trying to find a quick fix to something that doesn't deserve a quick fix. It deserves a lasting fix.
Okay, so we'll take a last question before we go into our next panel.
Thank you, Madam Chairman. Again, my name is Bill Inge. I'm the president of the North Slave Métis Alliance, a Section 35 Aboriginal rights organization that asserts its Aboriginal rights on the north side of Great Slave Lake. Thank you, Tom. And I'm well acquainted with Tom, as we have met on a couple of occasions regarding the Métis rights of the North Slave Métis. Now, Tom, a paper was distributed here this morning. It was authored by the law firm Pape, Salter, Taillé, and under one of the headings is the duty to negotiate with Métis and non-status Indians. And what it says here is the court reaffirmed, based on Haida Nation versus BC, Howsett Nation versus BC, and Pauli, that a context-specific duty to negotiate exists when Aboriginal rights are engaged. This duty is not triggered by mere inclusion in Section 9124. However, it applies where Métis or non-status Indian communities have credible or established Section 35 rights or claims. Now, my question to you, Tom, is the Métis have to rely a lot on consultation and accommodation lawsuits in order to ensure that their Section 35 Aboriginal rights are not trampled on. Now, for those of you familiar with court cases, it's better to do a judicial review of a Crown decision, because it doesn't take 7 years in court and millions of dollars to prosecute to get the court to act in some way. I'm wondering, with respect to what's written here, the difference between a consultation and a negotiation, because in both contexts, the Crown is obligated to consult and accommodate Aboriginal peoples where their Aboriginal rights are going to be infringed, or in our case, extremely affected by extinguishment. Is there a significant difference between a consultation and a negotiations outlined in this paper?
So my view on the phrase that the court uses in Daniels is that the duty to negotiate arises out of the consultation process, so it's not a standalone duty, but it's a duty that's immersed in the consultation when Section 35 rights, as the court says, are engaged. Now remember, that can be the assertion of an Aboriginal right or the infringement of a right. So there's two things going on. You can assert a right, that's the Haida case, or you can have a judicially established right that is being infringed. Both require consultation, and my reading of what the court said in Daniels is that the duty to negotiate, depending on the context, can arise out of that process, both in terms of infringement of rights or in respect of consulting on asserted rights.
Okay, thank you. It seems like really a splitting hairs, but I think a difference between a negotiation and a consultation are different.
I would just say it's a significant use of language by the court. I would not downplay at all. I don't think it's just enough to say it's the same thing. So I would tend to agree with you that those are special words the court used. So, and I'm sure your legal counsel will be relying on them in the future.
Yeah, thank you, Tom. Yeah, because to us, a negotiation means that there's going to be a respectful dialogue and an understanding that the Crown recognizes that the body that they're negotiating with has rights, and that a negotiation includes coming to some kind of a resolution over issues.
Thank you. So I'll take the last question, and
yeah, just some comments that I want to make, and it's no question, but just some comments that I want to just add here before I go. My name is Chief Calvin Bruno with the Papa Chase First Nation here in Edmonton. And our people were displaced partly because of the Métis script back in the 1880s. And eventually, they were part of this group. So that's one of the groups here that weren't mentioned this morning when you're talking about history. And they were part of these road allowance people too. They're ex-treaty Métis, as they'd be referred to. Same with Michelle Band. And so there's these, and Bob Tail as well. Their band was broken up because of the Métis script. So you got people and also others that were kicked off from the reserves back in 1950s, my late grandmother being one of them, who they had to live on the settlements because of a legislation, because they married a non-status man. And so there's other people as well too that are not included. Indian agents back in the 40s, 50s, arbitrarily kicked people off reserves. They had no place to go but the settlements. People that went to war, they were promised land when they got back. First Nations men that went off to war, came back, they couldn't get the land. They had to go to the settlements. So there's these different classes, these other groups that are being forgotten here. So I just want to make that clear. And as well, I want to mention something else. You talk about consultation. The Métis missed a prime opportunity here in terms of consultation. We have a burial ground down in Rossdale. There are Métis that were buried in there. I have ancestors that are buried in there on the Bruno side and the Papache side. And what happened was we've been fighting to protect this burial ground since early 2000s. And we protested, my band and I, excuse me, my band and I protested in 2012. And the province stepped in when they heard that. And they said, the city of Edmonton must consult with Treaty 6, 7, and 8, Papache, Michelle Band, and Métis Nation. When we met with the city, we ordered them to have site monitoring and archaeologists down there when they're building that new bridge. They complied. The province stepped in and ordered that. Now, from what I understand, the Métis hasn't been involved in this process at all. Your leaders have chosen not to be present. They've been absent from this whole process. And this is a prime example of consultation with governments and with industry. And we've been involved in this process. We found more bones on site recently. We had a reburial ceremony. We were present, other First Nations were present, but the Métis weren't present. Yet you have ancestors buried there. So I just want to leave it at that. Aye.
Thank you. Well, let's give a big round of applause to Mr. Isaac, and thank you very much again for your presentation. And then I'll call the other panel to come here.
We are going to carry on. We are going to carry on with the next panel. Please take your seats. We've got an exciting panel for you up next. My name is Daniel Voth. I'm an assistant professor of political science at the University of Calgary, and my job this afternoon will be to guide you through this most excellent of panels. How we'll proceed is we're going to reverse order in sort of the process. We're going to hear from Darcy Vermette first, then we'll hear from Darryl Leroux, and then finally from Madame Gaudry. And I've noticed that we have not yet had any women today at those mics. So I would like to encourage men, make some space. Women, we've got lots of brilliant women in this room. We should be hearing from you as well at both of those mics. So please do step up. Okay, so I'm going to introduce, it's my pleasure to introduce our first presenter, a fellow by the name of Darcy Vermette. So Darcy joined the Faculty of Native Studies as an assistant professor in 2015 and now serves as the Associate Dean of Research. Good work. Way to go. That's good. He's originally spent some time at a number of other universities, which you can read about in his official bio that's in the packages at your table. Including in that official bio a really interesting thing about a $423,000 Shirk grant to study and investigate Métis involvement as a treaty process. I think that's incredibly exciting. One of the things that is not on your official bio about Darcy is, first of all, that I think today he's won the best shoes competition. Oh, yeah. In addition, yeah, you should take a look at them. Also, Darcy is an excellent storyteller. He's a hell of a storyteller. I was at the Canadian Association of University Teachers meeting, and Darcy gave this fantastic story of the struggle that Indigenous academics find themselves in when they're in academic institutions, and it lit the room on fire. It was a fantastic expression of the complexities of being an Indigenous academic. His family fought at Batoche, and I think we're going to find out he carries on that good fight. Please welcome Darcy Vermette.
Well, that was an interesting introduction. Thank you. So before I start, I just wanted to say, I mean, usually you say thank you after, but I just wanted to say thank you ahead of time to all my colleagues in the Faculty of Native Studies. It is a terrific place to work. We have a great group of supportive people who really care about the development of the program and the success of each member of the faculty and staff. And so they inspire me every day to do some good work. This is not it. So I had this grand idea for what to do with this presentation, but it just did not come together right. So let's see. Let's start by talking about the wrong case. So here's a case called Tronson, and I know nothing of this case other than what's written in the decision. And I think that's enough, because the decisions have to make sense. They have to be rationalized in themselves. You shouldn't have to look beyond what's written and how the judges go about explaining something to make sense of the decision that they've reached. And I bring up Tronson because I read it a while ago, I don't know, 10 years ago or something. And I immediately thought, oh, there was that case where that guy was an Indian, but not an Indian. Right? And then I read Daniels. And the first time I read Daniels, I thought, this is terrific. 56 paragraphs, it's brief, right? You get some of these Supreme Court decisions on Aboriginal issues that are super long, just have a lot of nonsense in them. And then I read Daniels again, and I thought, where are the Métis people? The word's mentioned a lot, but there's no Métis agency in there. There's no way that the Métis are actually built into the decision-making process itself. They're decided upon, and that's what brought me to Tronson. So I'm going to talk about Tronson for the first few slides here. Tronson is charged in this case with unlawfully residing on an Indian reserve. It's not really, in the scheme of things, that big a deal. I think he's going to get a fine in the end. A few bucks that he's already paid through the legal fees and whatnot that he has to pay. So really, he's found guilty, but then can just walk away, right? It's not that big a deal on the type of punishment. But what they need to do in this decision is they need to just follow one simple question: is he a member of the band, right? And so you'd think, well, you can deal with that in a paragraph. You can just pull up a band list. You can see his name's not on it, and you can call it a day, right? You can all go and, I don't know what people do after decisions, go get lunch or something, have a drink, laugh about what just happened. Is that what people do? I don't know. Anyway, so you think it'd be pretty simple, but the judge spends an inordinate amount of time for a small decision deciding if Tronson is an Indian, right? Tronson needs to be a specific type of Indian, though. He needs to be an Indian who's a member of the band. So to figure out what type of Indian, or what qualifies as an Indian, then they go into the Indian Act itself and they find this in the definition. So first, an Indian is any male person of Indian blood reputed to belong to a particular band, any child of such a person, and any woman who is or was lawfully married to such a person. I imagine that the legislators who created this type of thing were big fans of children's stories. There's a lot of magic in children's stories. People turn into frogs, they get turned out back from frogs, and there's some magical wand or something. But I think the legislators were probably thinking, it's really hard to bring a magical wand into reality. And so, racking their brains for what to do, they decided, we'll use the penis. And so the penis becomes the magical wand that is able to determine the legal identity of other people, right? What they do in this case, then, is to decide if Tronson's an Indian or not, is they have two types of evidence. The first is the evidence used to show that he is an Indian. There's an old Indian woman She's 82 years old. She testifies Tronson was born on an Indian reserve. She saw the birth. There's another witness who's known Tronson for 50-some years. He says, yeah, it turns out Tronson was born on the reserve. He knew his mother and his grandmother. His grandmother, by this testimony, we know was an Indian. And the question is, was his mother? Well, I don't know, probably his grandmother was. It's not stated outright in the decision. So that's the other witness, the grandmother. Tronson, at the opening of the case, says, I was on the reserve because the community asked me to be there. So originally he was going to leave. So this type of evidence then is reaffirming his identity as an Indian and his presence on the reserve, right? Which are the two fundamental things that they're saying is wrong with his presence there. So how do they get around to deciding ultimately that he should be convicted? Well, they look at the official ban list. They look at statements of the Indian agent. They also point out that Tronson's father was white, right? Here's the magical wand. And the really tragic thing about this is if you follow the case, you can see that not only was Tronson made non-Indian because of his white father, but then because he was also the possessor of the magical wand, he turned his Indian wife into a non-Indian, and she couldn't reside on the reserve either. And this is problematic. Her mom's on the reserve. We learn that her mom is dying on the reserve. She gets temporary residence, but then when she applies to actually reside on the reserve, they deny her because she's no longer legally an Indian. Corroboration from the RCMP. And this bit becomes important. Tronson applies for a land grant, and he applies to get voting rights. It doesn't sound like a big deal. But it is a big deal because in the first one, there's a land act. This is an act of the, let's just say the Crown. I usually just make this nice dichotomy between the colonizer and the colonist. Let's just say the Crown. Tronson applied to be on the voters list as well. Both of these were successful. And the big problem is that no Indians can obtain these privileges. So they use all that evidence. He's not, to say he's not an Indian, and now they have this evidence to show that he is in fact white. Right. But it's the way that they frame it that's important. It's important to the type of agency that's involved in these decisions. The judge says, Tronson cannot blow hot and blow cold. He cannot in one breath say in effect that he is a white man and in the next say he is an Indian. The court goes on to say, no Indian is permitted to so apply. Tronson had his name placed on the voters list. This is absolutely fatal to the position Tronson now takes before this court, that he is entitled to the rights and privileges of an Indian under the Indian Act. Right. But if you think about this, Tronson is not saying this at all. Right? Tronson is adapting to a situation that's been imposed on him. If I say to you, what's your favorite drink in the world, Pepsi or Coke? And you're thinking, well, I like apple juice. Pepsi or Coke? Apple juice. No. Pepsi or Coke. Right? Your choice of Coke does not validate that as your favorite drink in the world. You're given two choices, right? You're adapting to the situation that is put in front of you. Tronson is not saying that he's not an Indian. He's adapting to the situation. He has lost his status, his right to reside on the reserve. His wife has lost that as well. What are they to do? They make the best of the situation. This is what comes up in colonial interactions between Aboriginal peoples and the state all the time, right? Aboriginal peoples are forced to make these type of adaptations. And what the court is able to do is to throw that back on them, to blame them for their decisions made in those circumstances, and in this case, to ultimately criminalize the person for violating some action, right? And so, what does this have to do with Daniels? Well, I think the same thing is going on in Daniels, not necessarily the criminalizing part, but the way that Aboriginal agency is removed from the decision. What we see a lot of in Daniels is what the Crown has done in regards to what they think Métis people are or aren't. But we don't see Métis people acting as a group of Métis people and therefore that fitting into the purpose of Section 9124. Right? Instead, we see things like, well, look, the Crown in this case allowed Métis people to be Indians, and therefore they're Indians. Right? They're not talking about Métis people or their actions. They're talking about how the Crown has imposed a definition on them, right, and moved them actually into a completely different category. This has very little to do with upholding Métis people as Métis. But that's how 9124 is going to get interpreted. So what evidence do they use? Government understanding of the words. So they break down the specific words, and actually a better example of this is the Re-Eskimo case, where they first decided that the Eskimo or the Inuit are part of 9124. I mean, they look at dictionaries to decide if they were included or not, among other things. But so sometimes this is what law is about, just the interpretation of one single word, right? But that understanding rests with the government. And it makes sense. I mean, if the Métis didn't draft it, it's kind of unfair to, holy crap, 5 minutes left. It's kind of unfair to say, what do you think of this piece of legislation if you weren't involved in creating it? So that's one. They look at the government purposes and intentions behind the Constitution. Basically, they wanted to use it to colonize Aboriginal people and take their stuff. Targeted government legislation as well, and this is mostly looking at mixed persons. Métis agency is found in actually asking for this declaration, I suppose. There's some mention in there that they cite John Burroughs for, that the Métis were a pain in the ass. And a mention that they were builders of Confederation, although the court never builds on this. They never say why or how this is going to influence the interpretation of this section. Just, they were kind of around at the time, I guess. Now, what's unfortunate about this type of interpretation is that the court sets themselves up to actually bring Métis in, to mean something in our Confederation. They say that the case represents another chapter in the pursuit of reconciliation and redress in that relationship. They say that reconciliation with all of Canada's Aboriginal peoples is Parliament's goal, right? And so we're going, guys, right? What the Métis think and do matters all of a sudden. It's going to be worked into the rationality of why they are now Indians under 9124. Well, I guess you know who I'm going to cite. Anyway. So they pull up John Burroughs, and he says, the Métis Nation was crucial in ushering Western and Northern Canada into Confederation and in increasing the wealth of the Canadian nation by opening up the prairies to agriculture and settlement. These developments could not have occurred without Métis intercession and legal presence. They also say Section 9124 must continually adapt to cover new realities. The setup between the reconciliation and this stuff couldn't have been more perfect. We're in. I don't mean just in as a sphere of jurisdiction. What you'd think from this stuff is that our histories are going to be written in there in a way that shows how Métis people were central in building the nation, right? I got to leave before questions, so can I take just a few minutes if I go over? Yeah. Sorry, I'm on a hiring committee, and the interview starts at 2, so I can't stick around for questions. So here, what you see then is at the trial, the judge is trying to do this. So what he talks about is these constitutional negotiations then, how the Métis actually sent representatives to figure out how this country is going to come together. Specifically, so that's the process, right? The process is incorporated into the trial judge's perception of things. And he's tentative, you can tell. I think it's a he, I don't know, I assume. You know, the magic wand or whatever. But so he's a bit tentative because of other decisions that have come before. You can see it in the way that he's writing about this stuff. So, but nonetheless, it comes up. They're involved in the process, and then the actual outcome, the Manitoba Act of 1870, comes up. You could validate that as a treaty, because a treaty is between two peoples. You could validate Métis titles to land because Métis are Aboriginal peoples. We're talking about their homeland. And you can create this narrative then in combination with the ability of 9124 to adapt and with the idea of reconciliation, that the Métis are actually creators of this constitutional arrangement. Right? I don't know. Maybe it seems like that's kind of pushing it. But really, if you're going to use this type of rhetoric of reconciliation, you got to walk the walk. You can't just throw that out there. I mean, typically what we see is reconciliation is used as a means to actually justify restrictions on Aboriginal rights. And, you know, that's a terrible type of duplicity. But if we want reconciliation, you better take Métis histories and make sense of them in this constitutional arrangement. There's also this Treaty 3 problem and this half-breed adhesion. But all of this signifies that the Métis as groups of people, right, had arrangements with the Crown. So why doesn't this make it into the, if some of this was mentioned at trial, why doesn't it make it into the Supreme Court decision? Why is it not part of their rationalizing their outcome? And it's because they've spent the past 15 years eviscerating Métis history. Even in these victories, if some of these are victories, they've underplayed Métis contributions and meaning in this Canadian history. So what we get is in Blais in when they talk about Section 31 of the Manitoba Act, working toward the extinguishment of Indian title, in that case they say, well, that's not really what it meant. I'm sure they say it with that intonation. They said it was recognized at the time as being an inaccurate description. And to cite this, they cite Sir John A. Macdonald from 1885. Right? The Manitoba Act of 1870 was at the time, and then they go to 1885. What's happening in 1885 that might make Macdonald want to underplay the Métis claim? I don't know. So, I mean, that's just terrible history. If you go to the Daniels decision, you can see that there's several moments in 1870 where Macdonald reaffirms that what they're doing with this section is actually extinguishing what they think is Indian title. So they do that. That's found in the Blais decision. Then in the Manitoba Métis Federation case, the court says that there's no pre-existing Aboriginal title. You know, it's not like it's written in the Constitution. So they underplay that. No treaty in Section 31. Instead, it's just an act of Parliament. They got a problem, though, because it kind of looks like a treaty. It is a treaty. But, so they call it they say treaty-like, which is great. Now we have to figure out how law makes sense for this treaty-like stuff, right? We conclude that Canada did not owe a fiduciary duty to the Métis in implementing Section 31 and Section 32 of the Manitoba Act, which is weird. Isn't that weird? Because if you read Daniels, it says that the way that they characterize Manitoba Métis Federation is actually recognizing the fiduciary relationship between Métis people and the Crown. But they found no fiduciary duty. So they're actually conflating two things here to advance their rhetoric. They're conflating the relationship with the duty, right? A relationship that is just basically rhetoric. You know, you guys should all look out for each other. And a duty is actually enforceable in law. They're not willing to find something that they can enforce, but they're willing to throw out these great terms: reconciliation, fiduciary relationships. That all applies. So what have we learned from this? Well, we learned that you can actually blow hot and blow cold. Right? The Crown can do it. What's really at risk here is the historical record as much as anything else, because law does that. I mean, look what I did with Tronson, right? I go back and I read this decision, and it's laid out a history before me. I think it kind of makes sense. I can make certain judgments on it. Maybe there's a whole bunch more circumstances in Tronson. I don't know. But I do have access to that decision. And future generations are going to have access to this decision too. And it's going to look like the Métis played no part in creating this nation. So I'll leave you with this. This is Gordon Christie. It is the imposition of the European vision to which Aboriginal peoples were and continue to be vulnerable, and this is what requires our continued due diligence in ensuring that how Aboriginal people are characterized in decisions or in popular discourse, that stuff is always challenged, right? That's our responsibility. And now I'm 4 minutes late for the interview, so I'm sorry I can't stick around for questions. I hope this kind of came together to make some sense, so thank you.
Darcy, that's great. Just a programming note, you'll notice that we are one panelist short. Jason Madden couldn't be with us today. He's fallen ill, which is fine because I don't actually have any dirt on Jason at the moment. So, our next presenter is Darryl Leroux, and Darryl is an associate professor of sociology at St. Mary's University in unceded Mi'kmaq territory. He's a white settler whose Norman and Breton and Parisian ancestors were among the first Europeans to colonize what we call now the St. Lawrence River Valley. So you could read that all in his official bio. One of the things that's not in his official bio is that he's a crack mackerel fisherman. And the biggest mackerel that he's ever caught was 16 inches. So that's a pretty honking, and this is out like on the ocean, right? This is on the open ocean, right? So it's dangerous, you know, and he's a great relation. Every time, I know when he goes out mackerel fishing, because he posts on his Facebook, I'm going out mackerel fishing, does anybody need some? Right? What a good relation. Please welcome Darryl Leroux.
What Daniel doesn't know is I've never, ever given a mackerel away. Again, there's a difference between rhetoric and, the duty. All right, so today I'm talking about les Métis de l'Est, or Eastern Métis. Unlike Darcy, who told us he wasn't giving his best, I am giving my absolute best, so I hope it goes well. All right, so I'm going to kind of go through this relatively quickly, but I'm more than happy to have conversation afterwards. In Quebec, Nova Scotia, and New Brunswick, since the Pali decision in particular, so since 2003, there have been at least 25 separate so-called Métis organizations that have been formed. I've just put up the logo of a few of them right here. Alongside this remarkable mobilization, there's also been the creation of a new scholarly field on the Eastern Métis. And my objective today is to outline 3 of the themes that I've identified in the French language scholarly literature through a review of journal articles, book chapters, PhD and master's thesis, and a couple government reports. All right, so the first theme that I want to outline is this, I guess what we can call alternative ethnogenesis narrative, or I'll call it the Eastern Métis ethnogenesis narrative. Basically, ethnogenesis, you can think of it as a story of origins in a way. So according to this first narrative, the Métis originate in either in the St. Lawrence Valley, so that's the most common version of this story. The first author I surveyed who discusses this is Étienne Rivard. He's a geographer in a 2004 PhD thesis, where he cites the following passage from the Nation Métis du Québec as a way to support the Eastern ethnogenesis thesis. We should never forget that the history of Métis claims in Lower Canada, Quebec, New Brunswick, Nova Scotia, Labrador, and Prince Edward Island established Métis forms of knowledge and political philosophy in the prairie provinces. Métis families in Quebec, such as the Riel, Dumont, Morin, Bonnet, Desmelles, and the Rivard families, and many others, already belonged as Métis. Their departure from Lower Canada, imbued as they were with their Métis identity for the promised land of Louis Riel's Métis Nation, promised them a territory accessible to the Métis, far from the grip and political constraints that the Métis lived with in Lower Canada. As it is today, the most prominent scholar arguing for this Métis Eastern ethnogenesis is Denis Gagnon. And this is a chart that he put together in an article he's written too, where he promotes this idea of the Eastern ethnogenesis in 2006 and 2009. In neither of the articles is there any proof or any evidence brought forward, except in the case of this chart, I suppose you could say here. So for those who don't understand French, I'll just explain this very quickly. You can see there's a strong line. So there's these red arrows. There are those that that aren't full lines. Those indicate people who are Métis and excluded, and those that are full lines are Métis, lead to Métis ethnogenesis, so the Métis people. So in the first group down in the lower left corner, it says Métissage, Maritimes, Quebec, and Ontario, 17th and 18th century, so the 1600s and the 1700s. And that leads to two groups of excluded Métis. Euro-Canadians is one of the groups, and the other one is status Indians. And then it also leads to the group at the top, the Métis Nation out west, or the Western Métis, who are as a majority Francophone in Rupert's Land in the 19th century. You can also see that there's another group that forms the Métis Nation according to Gagnon, and that is the Anglophone, or I should say Métis of Anglophone origin is what it says, from the 18th and 19th century. So this is just to give you a little bit of a sense. I'll explain this a little bit more. So this is a visualization of what becomes an alternative ethnogenesis narrative. So you can see here that part of what I've picked up through this literature is that this Eastern ethnogenesis is one of the primary ways to oppose the specificity of Western Métis claims. And again, no evidence is actually brought forward other than claims, statements. In a 2013 Senate report on the recognition of Métis identity, Claude Riel-Lachapelle stated, and this is in speaking about the Eastern Métis, the Métis in Western Canada are all from Lanaudière, Quebec, from places like Terrebonne and Saint-Gabriel de Brandon. It is all closely tied to the fur industry with the Northwest Company. That is an undeniable fact, and we cannot change it. In the past 18 months, as I've been researching this material, I've come across similar statements about 4 other regions of Quebec, including Gaspésie, the Trois-Rivières region, Vaudreuil, where a variety of scholars and or community leaders state that the Métis, as in the Western Métis, have their origins in a particular place in Quebec. An interrelated version of this story places Eastern ethnogenesis in Acadia. So it's interrelated, and sometimes they're clearly related, other times not so much. But essentially saying that the Western Métis originate in Acadia or in southwestern Nova Scotia in the 1630s and 1650s. Along a route between present-day Lunenburg and Yarmouth. I don't know if anyone's been there. I have. The mackerel fishing is great. 3 Métis organizations exist in the region today, and they share a belief in their historical role in founding the Métis Nation. Emmanuel Michaud, one of Gagnon's PhD students, explains this position. Raymond Cyr, among the other leaders of the Métis cause in the East, contends that before reaching the prairies, the population that would form the Métis Nation in the second half of the 19th century was already composed of Métis from Acadia and Quebec. Sear's story, and those of other Acadian Métis as they've now come to identify themselves, include a version of history where these Acadians from the 1630s and 50s basically migrate to Quebec around the time of the Acadian expulsion, which happens from 1755 to 1760. And they migrate to Quebec, the regions of Trois-Rivières, Gaspésie are the two regions I've seen. And after a generation or two, they go out west, found Red River settlements as Métis people, originally from Acadia. All right, so that's just a brief overview of this Eastern ethnogenesis. I can take some questions afterwards about what I've been reading and what there is about it. The second narrative that I want to highlight is the one that focuses pretty narrowly on French-English language politics or racism by English Canada, where the Western Métis oppress the Eastern Métis. So this one, again, is pretty common. For instance, in much of Gagnon's work, he argues that French-speaking Métis out east, out west, are being oppressed by English-speaking, quote-unquote, assimilated Métis. In his words, the official Métis associations of the West, who consider themselves to be the only true Métis on the planet, have ignored me because of my interest in French-Canadian Métis communities, who they consider to be assimilated, and unrecognized Métis communities in Eastern Canada, whom they see as opportunists. One Eastern Métis activist from New Brunswick illustrates this well in Michaud's PhD thesis. The Western Métis call themselves Anglophones. So why would they accept someone who wants to change their language? Because if you become a member of the Métis National Council and you're French, you will have to ask for your French language rights. So you can see it's a pretty conventional language dispute, English-French, and the English-speaking people are dominating the French-speaking. Michaud relies on his informants to conclude the following. Stigmatized by the English-speaking Métis who barely recognize their French-Canadian Métis cultural heritage, in Manitoba, French-speaking Métis people have sought support from various Métis communities with French-Canadian origins elsewhere in Canada and the United States. In the more extreme version of this story, where really the Western Métis are imagined as oppressing the Eastern Métis, you see that a number of scholars are becoming quite adamant about, or I suppose I should say extreme in the ways in which they're expressing what they see as oppression. So one of those scholars is Sébastien Mallette, an academic and lobbyist for various Eastern Métis bodies. This is a tweet from one of his accounts where he refers to the Western Métis as the Gestapo and how they're policing the Eastern Métis. Another one here where he compares the Western Métis to African people who took African slaves. I think it's a quite despicable image, but it's the type of imagery that's being used. So in this case, the people who are being enslaved are the Eastern Métis, and the people who are doing the slaving are the Western Métis. These types of statements are also made more generally about other Indigenous peoples. So notably the Innu or Mi'kmaq in Quebec. For example, Métis Russell Aurore Bouchard has compared trilateral treaty negotiations with the Innu in Innu territory as a type of apartheid that benefits only a tiny Innu minority. So Russell Aurore literally uses the term apartheid. Even Gagnon, the former Canada Research Chair in Métis Identity, has expressed similar language. The Métis are even trying to exclude the founders of the first Métis Union in Manitoba. This discourse is xenophobic. They are fear of the other. We should identify why they are so afraid that there are other Métis in Canada. What could this do to them? And the third narrative that I want to highlight is what is generally called in the literature in French the disappearance thesis. And it leads to the creation of Métis Indians. So this book here was published in 1995. It's called Le Dernier des Montagnais, or The Last of the Innu. And this book really popularizes the idea, which had been circulating in Quebec since the 1970s, that the Innu ceased being Innu in the 1700s because of intermixing with other Algonquin peoples and Europeans. This really becomes something that There's a whole social movement organized around, starting in 2000, 2001, after the Canadian government releases information about an agreement in principle with the Innu, 3 Innu communities. It was originally 4. And in the Saguenay-Lac-Saint-Jean, Côte-Nord area, there is a real backlash against treaty negotiations. So what happens is that one of the ways this backlash gets expressed is a very straightforward expression of white rights. So l'Association des droits des Blancs. Oops, I think actually it may have been down there at the bottom. L'Association des droits des Blancs, or the Association for White Rights, is founded at this time. Now, interestingly, the founder of that organization later founds a Métis organization in the region. He's still the leader of that organization, and he becomes Métis. So these are the types of dynamics that are playing out. The reason that that organization exists partly is to more or less torpedo these negotiations with the Innu, which has happened. The treaty has not been signed, and this was again in the 2002-2005 period. The Métis Federation of Canada, interestingly, has signed one of their treaties with that leader who calls himself the chief of this Métis organization. They have photos on their website proudly posing with him. And in 2011, the Liberal Party of Canada dropped him as a candidate in a local riding because of his expressly racist comments about Indigenous people. So Paul Charret, anthropologist at the Université Laval, who I think is now retired, provides the clearest description of this thesis, this disappearance thesis. There's a belief that by mixing with other Algonquin peoples and Europeans, 17th century Innu fundamentally changed culturally and biologically. The process, often in Quebec, is called intra-Aboriginal ethnogenesis. Innu emerge as a new people who no longer have Aboriginal rights as currently formulated. Innu become Métis Indians, same as regional Métis. So the regional Métis call themselves Métis Indians, and lo and behold, they also call the Innu Métis Indians. They all have the same rights. There are no distinct rights for Innu people. Charret says this approach denies the ancestral Aboriginal rights of the Innu by doing away with their ancestors. And finally, I have to say that this disappearance thesis doesn't have widespread support in the French language literature. There's actually quite a lot of material that critiques it, even mocks it, not so much academically, but in the popular press. But there's sort of a shadow of this disappearance thesis that comes out in scholarly material, I think, that disappears Indigenous peoples in Quebec. This is the Governor General in the mid-19th century, Charles Bagot, or Bagot though, as an image. Recently in a case involving the Communauté Métis Autochtone de Maniwaki. So this was a Quebec Superior Court decision. Mallette cited evidence from the Bagot Report 1844. In the report, it states that the majority of residents of the, quote, 7 Indian villages in the St. Lawrence Valley are Métis. And this argument is used today in this court case and otherwise to actually suggest that this proves the presence of today's Métis in Quebec, the fact that they were mixed-race individuals who lived in Indian villages, who were basically living with their Indigenous kin and communities. And I've just a few questions to ask about that. What is the effect of attributing Métis identity to the Anishinaabe, Algonquin, Mohawk, Innu, and Abenaki individuals living among their kin? Right, so who gets to decide that? In this case, the so-called Quebec Métis want to reclaim them as Métis. And why rely on the Bagot Report, which is the basis of residential schools, according to a consensus of historians, and whose sole purpose was promoting the civilization of Indigenous peoples as authority in defining Indigenous identity or deciding membership in Indigenous communities? So these are the types of reports that are used in court cases to defend these claims to Quebec Métis-ness. In my view, it speaks to a wider trend in the literature on the Eastern Métis of universal use of European, white settler, and/or Eurocentric thinkers to explain Indigenous life, past and present. There's literally hardly any engagement with Indigenous or Indigenous thinkers in any of this material. Thank you.
Okay, our final speaker is Adam Gaudry. Adam is an assistant professor here at the University of Alberta, cross-listed in the Department of Political Science and in the Faculty of Native Studies. He's working on a book that will be forthcoming in the next little while on Métis treaties, and you can read all of this in his formal bio, but one of the things that's not in his formal bio that's on your tables is that he can grow just the best beard. He's got it kind of a little bit on the go now, but I have seen this beard in all of its glory. It is full, and it can hide all manner of secrets and things. It is absolutely a beautiful sight to behold. It's so beautiful. If you kind of look back in the archives at some of our ancestors, many of them in the 19th century had those full, beautiful beards as well. And so I call, when he gets it up and going, I call it his badass 19th century beard. Adam is a tireless defender of Métis people and his Métis nation, and he is my comrade in arms. Please welcome Adam Gaudry.
Thanks, Daniel, and thanks everyone for being here. As Daniel said, my name is Adam Gaudry. My family is from northwestern Ontario, a little community on the Lake of the Woods named Sioux Narrows. What I'm here to do today is Darryl and I have published, we have a forthcoming piece on this. And one of the things that I wanted to do is take the kind of information and the narratives that Darryl presented and link that back to Daniel's. Because I think how Daniel's gets mobilized, as we heard last night from Chris Anderson, very often reflects these types of narratives, whether or not they're kind of reflected in the historical record. So a little while ago, one person tweeted at me, now that the Daniels case has been ruled upon, I intentionally fish unlicensed so that one day I can challenge it. This tweet and its confidence in the inevitability of Métis rights for what this individual would see as all Métis is premised on two misconceptions about the Supreme Court's Daniels v. Canada decision. First, many assume that the decision primarily concerns the allocation of Métis Aboriginal rights to a broad, self-defined group of Métis communities, the way Pauli identifies Section 35 rights-bearing Métis communities within the Canadian Constitutional Order. And second, it assumes that Daniels explicitly recognizes self-defined Métis communities outside of the Métis Nation. So setting aside the obvious that Daniels was primarily concerned with jurisdiction, not actually concerned with rights, I still want to examine the decision much in the way that Chris Anderson did last night. Because as he argued, jurisprudential interpretations of court cases aren't necessarily what gets taken up in broader public discussion. Rather, how the court is interpreted in these public discussions very often is the kind of dominant narrative about a court case. So popularly then, Daniels has meant many things to many different people, particularly those who want to see their recognition, groups like the ones Darryl was discussing, their recognition as Métis rights holders, even if they wouldn't pass the Pauli test, which is already set up by the courts to make that determination. Before I get too much into my analysis, I want to make a couple things clear so that So first of all, there are many post-contact Indigenous peoples, of which the Métis are one. But I want to be clear on my usage of the term Métis because I think it often gets, and I think some of these court cases reflect that, it often gets used as an umbrella term, as if all of these post-contact Indigenous peoples fit under it. The way I'm using Métis and the way I would hope that the courts would take it up in the future is to treat Métis as a people, because I think fundamentally we are a people, that we have a common history, a common culture, a collective sense of self, that like any other Indigenous people, makes us a nation. So my purpose here today is to interrogate some of the claims made about Daniels, not for the legal merit. There are many people in the room, I think, better qualified to do that than me. But I want to look at I want to be able to help us understand how a case that sought to clarify jurisdictional responsibility for different levels of Canadian government has been reconstructed by some as a Métis rights case, supposedly bestowing Aboriginal rights and recognition on the formerly unrecognized. In place of this, I argue that a Métis-centered view of identity and belonging is necessary, both politically and legally, and that Canadian governments and courts should concern themselves with Métis self-identification in matters of identity, rather than attempting to answer these questions themselves. Given that judges usually have limited experience with Indigenous communities, they are often poorly equipped to make the kinds of decisions requested of them, in comparison, of course, to the communities themselves. In response to this, I suggest we root our understanding of Métis identity and belonging in collective Métis experiences, both historically and contemporarily, in ways that respect our capacity to make the most fundamental determinations about who we are and who are our people. Since the Powley decision in 2003, as we've seen in a number of different presentations, a growing number of self-defined Métis organizations have laid claim to Métis Aboriginal rights based on long ago Indigenous ancestry. These groups base their identity on what Darryl and I call a historical process of racial mixing in an upcoming article we have. And by this we mean that these groups tend to interpret a mixed Indigenous European marriage, sometimes many generations back in one's family tree, as the existence of a definable Indigenous collective, which is often labeled Métis. Rather than rooting this collective on models of peoplehood, a shared history, historical or contemporary ascription as Métis, so calling oneself Métis, the common element in most of these organizations is simply the presence of a mixed marriage from no particular Indigenous nation within each of the members' family trees. So I ask then, what does a person with 200-year-old Coast Salish ancestry have in common with someone who has a, say, 300-year-old Mi'kmaq ancestor, and is this the basis for a common community understanding of self? Is this the basis for an Indigenous community? The membership of these groups rely on identification of a single nominally Indigenous ancestor from any time, anywhere, not common to a cultural or political community rooted in place and time. This phenomenon is perhaps most easily identified in the response elicited by these groups immediately following Daniels. On the Facebook page of the Métis Federation of Canada, a poster replies to a Daniels news item. In 1644, the first registered marriage was my great, and then there's some abbreviation, but great-great-great-great-great-great-grandparents, but yet I don't have a recognition of Métis status. The response of the Métis Federation of Canada's page administrator was simply, get your application in with supporting documents. Since the Métis Federation, like many other self-defined Métis organizations, sees identity primarily as a process of racial mixing, not linked to a particular community, time, or place, someone claiming an Indigenous ancestor from, in this case, 373 years ago, can logically become Métis. This phenomenon, made famous over the summer by the Mi'kmaq tribe intruding on Mohawk territory by Ganawage, the infamous Costco Indians, is quite widespread, but it has grown remarkably since Daniels. This is likely due to paragraph 17 of the decision, which states, Métis can refer to the historic Métis community in Manitoba's Red River settlement. I think what they really mean is Western Canada. I think we often confuse that kind of terminology. I think when we say like a Red River basis, that should be broadly inclusive of the prairies and the regions beyond, because I think there's a common lineage, a common linkage, a kinship network that was quite dense and very rich in the 19th, 20th, and 21st century that encompasses those areas. I don't know why it's focused on Red River. But basically, Métis can refer to the historic Métis community in Manitoba's Red River settlement, or it can be used as a general term for anyone with mixed European and Aboriginal heritage. That is, anyone from any time, any place. This, of course, does not attempt to delineate who meets this criteria, whether or not they possess Aboriginal rights, or whether ancestry from, say, 373 years ago would be sufficient to make one Métis, but it has caused much excitement amongst self-defining Métis about the potential to access their rights. And these newly formed organizations have seen their membership numbers swell rapidly in response to this decision. The impetus to become Métis following Daniels, however, is also reflective of larger social trends. There's a tendency, what scholars call an ethnic mobility away from whiteness, a movement out of whiteness to something else, that is motivated by the assumption that whiteness or white culture is in fact meaningless, yet seeing indigeneity as rich and full of meaning. And so for many who find their life unfulfilling, Becoming Indian, playing Indian, as Kim Tallbear pointed out last night, is a solution in this search for meaning, this lost sense of meaning in one's life. So Indigenous people become the solution to this crisis. In Becoming Indian, the struggle over Cherokee identity in the 21st century, Cersei Sturm labels this ethnic movement towards whiteness as race shifting, where individuals whose family who have supposedly ignored, suppressed, or forgotten their connection to Indigenous ancestors are now reclaiming this part of their family history. In a U.S. context, these ancestors, who are disproportionately purported to be Cherokee, and in Canada, increasingly, these ancestors are defined as Métis, although very often it is mixed ancestry of quite a long time ago. In a comparative context, Cherokee race shifters in the U.S. have developed nearly identical narratives to self-defined Métis in Canada. As Kim said, it's as if they're reading from the same script. According to Sturm, race-shifting Cherokees locate their past in a painful hidden history where their families were forced to publicly disavow their Cherokee identity due to intense racism, while maintaining some unspoken elements of Cherokee-ness in private, often in coded ways. For Sturm's race shifters, hiding is constructed as, quote, the product of grim necessity, lest their current efforts at Cherokee reclamation be called into question as illegitimate. Nonetheless, race shifters believe that their Cherokee ancestors are actively calling them to return to Cherokee-ness, to reclaim their lost culture. Central in such an argument is the unspoken reliance on what's called hypodescent, where a single drop of Cherokee or other Indigenous blood is supposedly powerful enough to, quote, remake one's entire racial, cultural, and social body into a full-blooded Cherokee. Ironically, their often minute and sometimes invented Cherokee blood content, they do not actually attribute the same hypodescent powers to other ancestors, say English or Irish, meaning that their Cherokee relatives, no matter how distant, are attributed unique spiritual powers that non-Cherokee are not. For example, one Irish ancestor does not make someone 100% Irish. But when these race shifters fail to gain entry into one of the 3 federally recognized Cherokee tribes, they often adopt what Sturm calls a neo-tribalist approach, claiming that if your tribe of origin will not have you because you fail to meet the standards for citizenship, then it is best to just start a tribe of your own. Self-identified Métis identities follow a similar path, and these narratives construct new Métis identities primarily through self-identification and a connection to an off-distant Indigenous ancestor. With this connection and the unstated power of hypodescent, new Métis envision a normative Métis subject who has a hidden identity and culture that has secretly and subconsciously been retained. This race-shifting trajectory is deeply bound up in the membership code of new Métis organizations, who, despite geographic distance and a fairly standardized definition of Métis identity, they all seem to have the same membership code. For example, the Métis Federation of Canada requires applicants to demonstrate, quote, a historical blood connection to an Aboriginal and European couple. The Canadian Métis Council requires that applicants be, quote, distinct from Indian and Inuit, as well as someone who has genealogical ties to Aboriginal ancestry. These new Métis organizations see themselves at least partly as independent arbiters of genealogical authenticity. Perhaps most bluntly, the communities of the Voyageurs Métis, another organization, state that getting a Métis status card means your genealogy has been verified to be true and accurate. It is proof that you actually are part Native. And part Native, in this sense, becomes Métis. These organizations unanimously equate a history of mixed descent with Métis identity rather than a common culture, making descent from an Indian ancestor, even if quite distant, to be the key factor. This is possible because Métis identity is interpreted primarily as a historical process of mixing, not belonging to a collective community with a common culture, a common history, etc. So the unintentional outcome of Daniels is that it has empowered these narratives. And I think it honestly probably would have done it whatever Daniel said. I don't think the decision is the problem. I think that there's a narrative beyond the decision, which would have been read into the decision regardless of what it said. But the outcome has led multiple groups to declare, as Darryl already pointed out, that they are the true and original possessors of a Métis identity that predate our own. They construct their self-defined Métis as older and truer than the Métis nation, and they see that our forced engagement with Canadian colonialism has rendered us too tainted or too connected to the modern to be legitimately Indigenous. Métis started in the East, as Darryl pointed out, as a refrain many of these groups are constantly restating, pointing to the Daniels decision's fleeting mention of a Métis community in 17th century Nova Scotia, from which the Métis nation is then said to be a mere inheritor of originary Métiness from Quebec and Acadia. In this imagining, colonialism is inverted. The newly Métis are now oppressed by the Métis nation, seen as too invested in the present with Canadian colonialism. In this sense, they don't see themselves a part of us as much as they see us a part of them. Daniels is seen in the court's recognition of this. The Métis began in the East. That's what they see in the decision. And though there's no substantive commentary on it in the text of the decision, and that every other substantial example of Métis people in the decision actually falls within the Métis nation homeland in Western Canada, this doesn't seem to matter. And in many cases, they actually seek to replace our organizations with their own. Groups like the Métis Federation of Canada not only see themselves as opponents to the Métis National Council, but vision in one day of kind of representing all Métis from coast to coast to coast, primarily by replacing the Métis National Council. So I think what's happening here is that there's a general disregard for living Métis nationhood that locates the promise of Métis cultural revival in blood or historical mixing, rather than to a connection to living Métis communities, of which there are a great number. This is what Sturm refers to as a presumed void of Indianness, or the belief that contemporary Indigenous communities either don't exist anymore or are less capable at explaining our own existence than outsiders are. But I would argue, and I'm sure many in this room would, that there is actually no Métis or cultural void to fill. There is no void of Métis-ness. Métis communities still exist, and so do Métis governments, all of whom, despite some shortcomings owing to a century of colonial interference, are generally responsible for safeguarding Métis identity and political interests. The end result of this is that Métis have already answered the question, who is Métis, largely to the satisfaction of Métis across the homeland. The Métis National Council's definition, for example, Métis means a person who self-identifies as a Métis, is distinct from other Aboriginal peoples, is of historic Métis nation ancestry, and is accepted by the Métis nation, I think is both broadly inclusive, but also maintains the distinct usness, of the Métis nation. This definition is flexible in that it can account for the many ways that Métis have been disconnected from family, community, and nation by Canadian colonial structures, but at the same time, it preserves a sense of common belonging and common history. This isn't rooted in a historical process of mixing, but a common history and collective culture. It's a way that we can bring people home. But it is not only self-defined Métis that actually presume this void of Métis-ness with which they can fill, because the Canadian courts actually assume it as well. And I think Darcy pointed this out nicely. Like the issues presented in Daniels, the courts could have simply looked to the Métis people to make sense of the question, who is Métis? Instead, and they did the same in Pauli, they presumed there was a void to fill, and they appointed themselves arbiters of Métis identity and stumbled into an area that I think it's fair to say they didn't fully understand. And again, the courts could have always deferred to the Métis nation itself, as it is still intact and able to make decisions on a Métis identity and belonging, and many Métis organizations are now entering talks which will hopefully become land claims agreements. The Métis nation is a still living entity capable of exercising these types of responsibilities and outcomes decided upon by Métis people, and these outcomes will always be more legitimate and more sound than those devised by Canadian institutions. The problem is that Canada has been long hesitant to allow Indigenous communities to manage our own affairs, and indeed this is the mainstay of Canadian colonialism. In the end, what has been lost in the debate around Daniels is that Métis people ourselves are capable of deciding on and using our own terms to decide upon who belongs. Of course, we've already done that, but this isn't always recognized by the courts. This is a fundamental part of self-determination, however, and that Indigenous communities have always had their own criteria for determining who belongs. In many instances, these are spelled out by clearly articulated membership codes, and generally, these should be respected as the contemporary embodiments of much older forms of membership and kinship practices. The courts could have empowered Métis peoplehood in Daniels, and they could always do so going forward, but this would require fundamentally the Canadian courts to support Indigenous legal orders rather than to override them. And this would be inconsistent with Canadian political practice to date. While such a shift would be challenging, it is the more just course of action, as well as being in keeping with the Canadian government's own rhetoric about respect for Indigenous self-determination. Recognizing this reality and supporting Indigenous communities in making these determinations assists Indigenous people in re-empowering ourselves, but ignoring it only retrenches Canadian colonialism further. The Micanacs, the Métis Federation of Canada, and increasing numbers of others seek to gain something at the expense of Indigenous communities, as we saw, perpetuating Indigenous political disempowerment in the process. Indigenous people should resist this, and if Canadians, the Supreme Court of Canada included, are serious about reconciliation, they also need to confront the many they empower to reimagine themselves as Indigenous by continuing to ignore community-based definitions of belonging. What is at risk is the most fundamental of Indigenous people's rights, the right to determine who we are. Canada and Canadians need to respect this and to stop pretending they know better. Thank you so much.
All right. We've got a wonderful set of ideas there to work through. Just again, a reminder, we have not had any women at the mics yet thus far. So men, let's take a little bit of a breather and maybe you're transgender. And invite other folks to come up to the mics and see if there are folks. Go ahead. Oh, are you coming up to the front, ma'am, miss? Just hang tight. Yeah, come on up. Just hang tight.
Thank you. Thank you very much for pointing that out. It was very obvious that there is no equality within the context of our mutual respect for each other. So it's something that can be easily solved, though. It's not insurmountable by any means. But I would just like to say that the analogy of the magic wand was very good. It really pointed out in a very lively way what we're up against. Seriously, the inequities between the women and the persecution of Indigenous women include Métis women as well, and it's exceedingly serious. My name is Muriel Stanley Venn. I'm president, founder of the Institute for the Advancement of Aboriginal Women. And right now, right this very moment, we are very concerned about the Cindy Gladue case and the total disrespect that the courts had in regard to Cindy's body. As you know, must have heard that they dissected her private organs and brought them to the courtroom in a paper towel as a specimen, which in itself, the dismemberment of a dead body is a criminal offense. So September 7th, we had the appeal court, went before the appeal court. the Institute for the Advancement of Aboriginal Women and the LEAF organization were able to intervene, which we were pleased about, but they only, you'll understand this, they only gave us 20 pages, and we couldn't speak. So that was very limiting, and of course was a disappointment to us. But it's just in the long list of inequities that women face, it's just one of them. And I would hope that this venue, this session could talk about the involvement of women and how important they were and are in the lives of us as citizens. And the destruction of the Indigenous women is a crime beyond comprehension, and unfortunately Canada is known internationally, or has been known, as a compassionate and loving country. And it is to most people, but not to the women of this country, and especially not to the Indigenous women. But I had my thoughts about Stan Daniels and his role that he played in the whole Métis scene. And somebody remarked that if Stan was here today, he'd be saying that Canada should look after its Indigenous people first before they bring in refugees. And of course, our hearts go out to the refugees, but that doesn't change our own lives. So I think that we have to take some stands and be emboldened by the Truth and Reconciliation Commission, and be emboldened by the Declaration on the Rights of Indigenous People, and be strong knowing that we have that bond between us, and to support us and to make us more citizens and contributing citizens. There are good signs, but it's the most challenging time I can ever remember is now. That in this province we have a government that has recognized the women of this province, and that's so amazing, because for 42 years you'd think there wasn't any women living in Alberta. So no, there was truly no way of petitioning the government as it stood to have any department of women's rights or status of women or anything like that. It was totally blocked. So I thank you for this opportunity to talk, and I'm glad that again, repeating myself, that this was made obvious to us, and that we can change it, and for the better. Thank you.
Jimmy Gwitch.
My question is, I guess it's really nice that you guys came here from the East, because it certainly has been the sentiments, some of the things that you have said there, Mr. Leroux. And, sorry it had happened like that, but, it is what it is. It's played out like that. So I guess the question for me is, like I said, I'm a counselor in Buffalo Lake Métis Settlement, and one of the things that we do deal with is membership that comes through our office, through our chambers. And the issue that I have seen in the first term, and this is my first term as a counselor, is that we don't have a means to check an individual. If an individual came from your area, we don't have a means to check that individual. And so I guess the question is, and because I have not been involved in the federal level as per se like you guys have, but we know that the Innu, and the treaties, they have a national registry of some sort that would confirm that you are of that group. And so if you were to go from one reserve to another, it's there. So, but the thing is, for us Métis, we don't have something like that. And the issue is how to prove Métis. What's acceptable form to prove Métis? That's the issue that is playing before us. We're only an hour and a half from Edmonton. And of course, you guys know that this is the hub of the oil and gas activity. I'm surprised personally that there isn't more Métis that have applied in the settlements, but that's not for me to say. But the thing is, we do seem to see that there is more. And so the issue is, when you guys talk at that level, are you guys talking about something as a national registry, or because, you know, MNA is not the only political party or Métis party. Same with every province has their smaller groups there. So what's going to be an acceptable form of Métis standard, I guess, to be identified as? Thank you.
Darryl? Oh, I'm sorry, I was just guessing. Hit the button again.
Oh, is this working? Oh, it's working now. Thanks for the question. Appreciate it. Before I answer, I just wanted to say, I've been meaning to say this when I started, but Chantal, who was in touch with the people who came here for the presentation, was an amazing organizer. Chantal Leroux, who I don't know if she's in the room, but I just wanted to give her a shout out because yes, thank you. I've never had such a good experience coming to a conference, and just like, she was so on top of things, so I just wanted to say that out loud. To be honest, I don't have an answer for that question specifically. I feel like it might be something that's discussed later or tomorrow, the Métis Registries panel. That's where I want to leave that question. Sorry.
Adam, do you want in?
Yeah, I'll leave it mostly for that panel as well. I think that they're the experts in many ways, and but I think that I guess the key component is that with so much about Métis governance, I think the key factor is that it's ours. Like whatever form such a registry would take, like I think it belonging to us and not being like a federal registry.
But even in his group that he converses with, are they talking something to that effect? That's what I was after, more or less, for you.
Oh yeah, so yeah, yeah. Oh.
So I'm not really in conversation with any groups. I was reading more the sort of material that is available, telling sort of basically legitimizing the idea of there being Eastern Métis. I don't know exactly what those groups are calling for. What I could say about the question of membership is what I wanted to highlight in my presentation, primarily because all of this is happening in the French language. So part of what I wanted to do was translate that material and present it to you, so that for those who don't understand or read French, that you'll be aware of what some of these organizations are doing, and also how they're opposing Métis people out west in a number of ways. But I think it's important to have those types of conversations about, like, you know, how do you decide what sort of boundaries that you put in terms of identities and membership. All communities have that. So I think that's your question is pretty much what I guess part of my presentation was meant to evoke. But I think the people tomorrow have more of an idea about that. I can't really speak to what some of the organizations out east are looking for exactly when it comes to registries, et cetera.
Gabriel.
Hi, yeah, Gabriel here. I just want to clarify your concerns with Daniels is that there's just going to be all these Métis everywhere popping out of the woodwork, and so what are you saying, that we need to, like, policing this that situation, or what's the, like, okay, here's a question. Are you for or against the Daniels case?
Well, I think that Daniels has been misread by people to not about jurisdiction, right, which was the main focus, which I think is both historically, legally, and morally, Métis have a relationship with the federal government. Like, I think that's an obvious thing. And in that sense, I agree with it. The only issue I have with Daniels is that paragraph 17, which I think the judges wandered into an area that Métis have been debating forever, without fully understanding the context in which they are entering that, which has led to groups, many like the ones Darryl was describing, to kind of claim a Métis-ness. And like I said, I don't think I think that would have been the end result regardless of the decision. If the decision was the exact opposite of what it was, I think people would be still finding a way to read Daniels in a way that reflects what they wanted it to be. Not that it's necessarily, like I think what the court case said for this particular issue is immaterial. Like it was going to happen this way because they were always going to read this into it.
Okay, so it was paragraph 17.
Paragraph 17, yeah, which is
your loose end.
Yeah, and I mean, I'm not even sure that they meant to kind of make that into a new test. Like, it's not the Pauli test, right? It doesn't have these kind of strict criteria.
Yeah.
But it kind of made this comment, which left something open that really wasn't open before, and some people kind of, I think, are attempting to move in. Yeah.
No, that's cool. I just, I know we're all not going to agree and
for sure.
whatnot, and that's all good. I just wanted to clarify on that. Thank you.
Yeah.
Thanks. If you were here last night, you'll remember Chris made, he had an image up here with the galloping rabbits. I think that's what we're talking about. The rabbits go in different directions.
Tony.
Excuse me. Unfortunately, I'm not going to be here tomorrow when there's a discussion on registries and the other panel, I forget what it is. What I have to say is sort of connected between this one and the others, and also just a general statement about the conference. First of all, I want to thank the organizers. I think it's fantastic what you've done. And not everything can all be done at one time. We have a lot more to do. One of the things it seems to me is that we need to have a discussion about the correlation between Pauli and Daniels and how each affect this whole discussion about Métis identity, who may belong, and all the rest of it. For one thing, the courts have no business defining who we are in any way, shape, or form. Although I stood behind Steve and Roddy Pauli in the fight against their fight for the recognition of the right to hunt and fish for food, we got taken in by the courts in ending up with a definition. It's a wrong definition. It's something that needs to be corrected in future law. It's okay to say, as the Métis National Council does, for example, Métis are descendant from historic Métis communities. Well, what are those historic Métis communities? And if we look at international norms for the definition of peoples, it's self-identification and community acceptance. Well, what is community acceptance? Where does it begin and where does it end? And who gets to decide? Is it a national lobby organization? Or people at the community level? Who gets to decide? It's definitely not the place of the courts to be determining. Now, the courts in Pauli have said to exercise Métis right to hunt, fish for food, you have to meet this criteria. Well, I know from experience that there are communities that have come along post outside control. Well, what about those Métis communities? Do they get abandoned because the courts have said to us somehow Métis now have to be defined by those who can exercise a right according to their definition? Or do we say to ourselves, we're the ones that have the right to say who belongs? And should we be led around by the nose by a court decision that is, at the very least, incomplete? And definitions are made to serve a purpose. And not one definition necessarily serves another purpose. So what the courts have said, the right to hunt and fish for food, for now, means these people. Well, I think it's folly for us as a people to say, we're going to now determine, because of that court decision, who may belong to our communities, both at the community level and at the national level. Because I'm not going to be here tomorrow, and there are other panels dealing with that, I wanted to just bring that forward. And again, I do want to thank the organizers for this conference. It's a wonderful conference, a great experience. Thank you for inviting me.
Thank you.
Thank you very much, Christy Belcourt's dad. So we are at time. We're actually 5 minutes over into the break. Joe, can we pick it up in the break in conversation?
No, you can't.
Oh, okay. Well, there it is.
This is my meeting, not yours. Okay, there was something that came up, and I heard you guys talking about all this, how do you identify and so forth. And it all seems to be legal, and that's fine. I can appreciate that, and I can understand it. But you know, when you're identified, years ago when I was a young man, and there was a lot of elders around that time, a lot of that responsibility was given to elders. The moment there was a child born in the community, the elders were asked, what is that child? Where does he belong? And there was a reason for doing that. The culture had to be included, the language had to be included, the values had to be included, and many other things, because that was necessary in those days. And like I said yesterday, it was not advantageous to be an Indian in those days, because you were reserved and you couldn't leave the reserve, and you were numbered, you couldn't go in a bar, you couldn't vote and all that. So it was necessary for Métis people to make sure that that child was identified. And I don't know, you put all that legal crap around it, then, pretty soon you change that thing. But to us, that's the way we identified, and it's not used. And you people that are sitting out there, you should understand that. You should go back and talk to your grannies and the old people and say, that's the way we decided in those days. In those days when a child was born, the moment it was born, the parents were asked, what should we do with this child? And of course, a lot of them were right off the bat identified, but there was a lot of them had to be identified. So if we could use that, then I think this problem would be resolved. But I know the legal system wouldn't allow that. They'd come and say, oh no, we're not going to let you do that. But that's taken things away from us. That's taken our history away from us. Because I remember in those days, that was the best way to identify, and we knew. And the reason, like I said, I make very clear, it was done legally as well from our side, because if we didn't identify that child, then they would take over. So I think it's necessary to remind you guys there is a system. We had a system, and it still works today. But then along comes social services, and they decide. Do you know social service has more authority than we have? So that's what I'm saying here. If we go back to our traditional ways, we know who we are, and we can identify all the Métis people in the province. Hey.
Thank you,
Joe. Okay, go ahead, Muriel.
Yes, I said this problem was solvable, and I think that we should call on this conference to indicate that in future conferences that the consideration for women, because in effect what's been told to us as women is there's nobody qualified to speak. If there are no speakers sitting on that except a one or two or one, then we're told that there is nobody has the ability to do that. So I'd like to propose a revolution or a resolution, whichever, in which if we believe that our women are important, our mothers are important, our grandmothers, if we believe that, then we will do the right thing to make sure that in any future conferences that are being held, there be at least an equal, at the least, and there could have been a women's panel, because everything that's being discussed affects us as women, and we're very concerned that our voice is not being heard. And so the resolution is that at all future conferences, consideration will be given by perhaps a committee of women and elders to discuss what the implications of this is. And this voice has been missing, but it's about time. Thank you.
Jimmy Gwitch. Strong ending point. Thank you very much, everyone. We are a little bit into the break. The new panel will kick off at, Nathalie, what time does the next panel? 3:30? 3:30. See you back at 3:30. Thank you very much.